everyone, and welcome to this video tutorial on the defence of consent. The defence of consent is widely used in common law as a defence for non-fatal offences against the person, such as battery. The defence of consent acts to defeat an element of the actus reus of the offence to turn what would otherwise be a crime into a lawful action. So, for example, we know for battery that the actus reus of battery requires the application of unlawful force. If a person has consented to touching, then the force is lawful and it is not a battery. The defence of consent is a really interesting defence because it's recognising that people have a degree of choice and responsibility over their bodies and lifestyles, and they can subject their own body to a certain amount of harm legally, such as getting piercings, such as getting tattoos. However, there's going to be a level at which the court would not allow someone to abuse their own body or the body of another human being, because that would be against public policy. The defence of consent is really interesting, and it could make a really good essay type question on exam 3, where you're being asked to consider to what extent the law balances an individual's right to choose, personal autonomy, with the law trying to balance that with paternalism and public policy. Let's have a look at how the defence works then. So as I've already said, consent, we call it a defence, but when you look at it, it works a little bit like self-defence does, that it actually operates to defeat an element of the actus reus of a crime, and it turns the action lawful rather than unlawful. So I gave you the example at the start that battery requires unlawful force, and if you've consented to being touched, then the force isn't going to be unlawful. It doesn't apply to all crimes, however, and we'll have a look at that. It doesn't apply to murder. So although the actus reus of murder says there's an unlawful killing of a reasonable person in being, you can't consent to your own death to turn what would be an unlawful killing into a lawful one. For other crimes, however, where it is available, it will absolve the defendant of all liability. So, for example, it won't be rape if the person has consented to sex. For ABH and GBH, the courts have taken quite a restrictive approach to what you're able to consent to, because they generally don't like people consenting to a high level of personal harm. The defence of consent is not a defence to murder, and we know that already from studying the law on murder. A case that we can use here is Pretty in the UK. And if you remember this case, it was really tragic, involving Diane Pretty, who was suffering from a degenerative condition, motor neuron disease, and she wanted her husband to help her to commit suicide because she was physically unable to take her own life. So she wanted an undertaking from the court that if her husband assisted her, he wouldn't be prosecuted for murder. However, the court held that euthanasia is illegal in the UK. Consent can never be a defence to murder. So even if the person is saying that they want to die, they want to end their own lives, the law will not at the moment allow that to happen in the UK. You can't consent to your own death. Having said that consent is not available to murder, though, consent can be a defence to manslaughter, which might be surprising to you. So we're going to look at the case of Slingsby here. Of this case are quite interesting. The defendant, Simon Slingsby, and his girlfriend liked to engage in fisting, or, as we've got here on the slide, vigorous sexual activity. And importantly, the victim, the girlfriend, always consented. Now, this guy, Simon Slingsby, always wore a big signet ring. And he mustn't have washed his hands very often because this ring was grim, it was dirty. And while they were engaging in this fisting with consent, Simon cut his girlfriend on the inside of her body with the ring that he was wearing. And the victim didn't go to the hospital with these internal cuts, and they later became infected, causing the girlfriend to develop septicemia and die. And the issue in this case was, could our defendant be guilty of unlawful act manslaughter? Now you can see here from our principle that because the girlfriend had consented, there was no battery, and so therefore our defendant, Mr. Slingsby, was not guilty of unlawful act manslaughter. So consent was a defence to manslaughter. Students are sometimes a bit confused about this, so I just want to quickly remind you of the requirements of UAM so that you can understand Slingsby here. So in order to convict Simon Slingsby of unlawful act manslaughter, he would have had to have done an unlawful act which was dangerous, which caused the death, with the mens rea for the original unlawful act. Now the prosecution was saying he'd done an unlawful act, the battery, the fisting. They said that that action was dangerous. I'm sure you'd all agree. It clearly did cause death, and he clearly did intend to do the original action, the fisting. Certainly wasn't accidental. But he was not guilty of unlawful act manslaughter because he'd not met the first requirement. There wasn't an unlawful act. Because his girlfriend had consented to the fisting, that meant there was no battery, so there was no unlawful act, so it couldn't be UAM. So you can see there that although consent cannot be a defence to murder, it can be a defence to manslaughter. And I think this shows just how sort of extreme the defence can be, that consent can work even if a person has died. Some rules on consent though for it to work, and firstly we say that there must be true consent, or another way of saying it, there must be genuine consent. Consent is positive, it's not a matter of the victim not objecting or not saying no, and consent differs from submission and submission out of fear. And this is a very unpleasant case on this point, Olugbosia. Our victim here had been raped and seen her own friend raped too, and when the defendant tried to have sex with her again, she submitted. And the defendant claimed that because she wasn't screaming and punching and hitting him, that she was consenting. And the Court of Appeal said that submission is not real consent. And it's always going to be up to the jury to decide if consent is real or not. The issue of consent being true or genuine, we've then got the case of Tabassum, where our defendant was a very strange individual who wanted to feel women's breasts. In order to do that, this defendant pretended to be a doctor, dressed as a doctor, had a clipboard, went onto a ward in a hospital and told women that he was compiling information for a database to help with breast cancer research. And would they mind being examined? The women consented to that, and then obviously it was discovered that he was not a doctor. So he was being prosecuted for batteries on these women. He's trying to raise the defence of consent, saying, well, they all agreed to let me touch them. But their consent was not valid because the women's consent was not true. They didn't really know what they were consenting to, and so therefore our defendant was found guilty. So this is showing that fraud can vitiate or take away consent. Consent can be express or implied. So express consent is where the person has expressly said, yes, I consent. But implied consent means that a person can consent to an action without explicitly granting permission, that we simply infer it from the situation. Here is that consent to battery is impliedly accepted by all people who move in society in a really busy area. They are exposing themselves to the risk of bodily contact. So if you are going onto a busy tube in the London Underground or walking down a busy corridor, although you're not expressly saying you're consenting to slight touchings, the law will imply by the fact you are there that you are impliedly consenting to some small touchings. And in Wilson and Pringle, the court said that implied consent is given to the ordinary jostlings of everyday life. So people are going to stand on your toe, people are going to accidentally nudge you in queues and things like that. We cannot have batteries in all of those situations. We imply consent there. The criminal law generally recognises consent as a defence in sports. In sports such as boxing and rugby, it's within the rules of these games that physical contact is going to happen. Now, the rule on consent in sports comes from the case of Barnes, and it says that participants of sport consent to injury within the normal rules of the game. So, for example, if you are boxing, you are consenting to being punched in the face because that's within the normal rules, but you are not consenting to have your ear bitten off because that's outside of the rules. But this case also says that if an injury is caused during sport, usually this should be dealt with by the sports club, and only if it's really serious should it be dealt with by the criminal courts. And there's a practical reason for this, of course. We wouldn't want every little tussle that happens on a football field around the country to end up in the courts. Our courts would get blocked up pretty quickly. So you consent within the normal rules, and if there is an assault or a battery that's taken place, then the sports club should usually deal with it. Look at consent to minor injuries now. And as a matter of public policy, generally a person cannot consent to being harmed. So if two people willingly engage in a fist fight, as was the case in AG's reference, their consent to being harmed by their opponent won't be recognised in law. The Court of Appeal in this case said that consent couldn't be a defence to Section 47 ABH or greater because it wasn't in the public interest for people to be doing this. And they listed exceptions to this rule. So you can consent to harm which is greater than ABH if you are taking part in a properly conducted sport, for lawful chastisement or correction of children, for surgical interference, that would include things like tattoos, and dangerous exhibitions. We've got the case of Brown here, a really famous case where 5 people were convicted on various counts of ABH and GBH under the Offences Against the Person Act 1861. These injuries were inflicted during consensual homosexual sadomasochistic activities involving things like putting nails into each other's willies. But there was consent to all of those activities, and none of the individuals were seriously harmed. None of them even needed medical treatment. But the House of Lords held that their consent was not a defence, even though they were all adults and even though the injuries were minor and transitory. Lots of academics have talked at great length about how this was a potentially homophobic decision, where you had judges such as Lord Templeman saying that society is entitled and bound to protect itself against a cult of violence, talked about this being an evil behaviour and that we needed to protect our young men in society from being influenced by this. The idea being that if people heard that this was going on lawfully, everyone would be doing it. A ridiculous argument and a very unfair decision. Particularly unfair when you contrast it to the case of Wilson that was just a few years later, where our defendant branded his initials onto his wife's buttocks with a hot knife. Again, she'd consented to that, but unlike the defendants in Brown, she actually had to get medical treatment for her burnt backside. The Court of Appeal stated that her consent was valid here because it was not in the public interest that this kind of consensual behaviour should be criminalised. They compared it to just like having a tattoo, and tattoos are lawful, so this should be okay. But if you follow that rationale, then the activities that the defendants were doing in Brown with the nails, you could argue that's just like having a piercing. So it does seem to be discriminatory because they were homosexuals in Brown, and here with a heterosexual couple, the consent was lawful. Another cause for concern with the defence of consent is something called mistaken belief in consent. And in the case of Jones, the court decided that a genuine mistaken belief in consent could be a defence with rough and undisciplined horseplay. So if boys mistakenly believed the victims were consenting, they could have the defence even though they were not consenting, which is rather worrying.